Hi everybody, my name is Marcella Dominguez, and today I'm really excited because I am going to have a conversation with Jacob from Just Creative, and I know that he has a lot of questions that a lot of you are going to have. So this will be a really great conversation for you to follow in on.
Hi everyone, this is Jacob Cass and I run Just Creative, which is a design agency and branding firm. And yeah, I'm really excited as well to talk about this because trademarking is something that I come across a lot. I specialize in logo design and branding, so a lot of my clients come to me asking what trademarking is, how they can get their work trademarked. And yeah, to have this conversation will be eye-opening for myself and my clients as well. So I want to ask, first off, what is trademarking and what's the purpose of it? Why does someone get their work trademarked?
So, on a very basic level, the reason that someone would want to register their trademark is so that no one else can use it in the category or in the identification of goods and services that you are using it. So, they use a lot of identification of goods and services isn't really like fancy terms, but I mean, I feel like it's a really complicated way of saying whatever your business is. So, like having a registered trademark protects you in whatever your business is.
Okay, let's say I have a client that does, they brought out a food, let's say food, and they want to register the logo, and they don't want that name or logo to be taken from someone else because they want that to build that brand with that name and that logo. So what would be the process of protecting that in the industry of the food and beverage industry?
Yeah, so usually food and beverage, let's just say it's beverage because we want to be even more specific when we're talking about identification of goods and services. So like it'll usually be like water or sparkling soda or, something like that. And what you're going to want to do is, first your client has to know whether or not they're ready to invest in the application process. And the application process usually costs somewhere between $225 to $275 per class. So in your example, you're asking me about beverages and then food. So that could be considered two different classes for which they'd have to pay $275 for each class. But let's say they're not ready to move forward and they say, you know what, let me just test the waters. Let me see if my brand is going to be viable first. Then you want to, at the very least, put a TM next to the brand name. And I'm sure you've seen that on like millions of brands, product packaging or whatnot. And it's to the top left with a T and an M. And so basically what that does is it kind of puts other people on notice. It's a placeholder for you. That you are using this name or this brand or this logo or this tagline in this particular category, in this particular industry. So it would be in the food and beverage industry. Now, if they're ready to move forward with a registered trademark, then yes, it would be a matter of, okay, let's identify, the categories as the USPTO has them outlined. So it's not a matter of you choosing your category. It's a matter of you knowing your category and then selecting the right categories from the list that the USPTO already has. And so that designation is super, super important because if you mess up that designation, then you kind of don't have protection for your brand. And that is the whole purpose and the reason for that application is to protect it in that industry. So that's like one of the most important tips that I could give.
Awesome. And I know we were talking earlier about this and I asked you, how long does the process usually take? And you said between 11 to 12 months or 14 months, you said. Can you tell us again or tell everyone why that is the case? Why does it take so long? And should people be putting this TM mark on their work in the meantime as well?
Yeah, so the process does take 11 to 14 months. And like I was telling you, I think people are always really put off by that because they expect it to just make a call and have in the same way that you would have a contract done and given to you probably in the next couple of days, maybe even weeks. I think people have that same expectation with a trademark application, a registered trademark, and it doesn't work like that. It takes anywhere between 11 to 14 months. So by that time, you may have even forgotten that you filed an application, that you spoke to a lawyer to begin with. So it's frustrating for some people. But I think that that's why it's so important to get it out of the way and talk to a lawyer about initiating the application, because a year from now, you're going to wish you had already done it back then, just because of how long it takes. And there is a process. So at first, it's assigned to a trademark examiner, and then the trademark examiner kind of takes it through a process. And that process isn't like, one that they actively tell you about. It's not like they say, okay, you're in phase 1, you're in phase 2, 3, 4. No, it's just first it gets assigned to a trademark examiner, then the trademark examiner reviews that application to make sure that there's enough information there to properly make an analysis. Then it goes through the analysis phase. Okay, let's, look up other similar marks. Is there any type of trademark infringement issue here? What other issues are present in the application? And if there are, then they send you a letter telling you that you have to fix these issues. And if there aren't any issues, then they kind of, the application just goes about its merry way. And so that is kind of where people get stuck. They feel like, oh my gosh, I received this letter and I have no idea how to fix the issues that are in there. And then there are other people that, say, I didn't need a lawyer. I did it all by myself and I didn't have any issues at all. But my point is just that is why people hire lawyers for this type of stuff, because if you do receive that letter, I mean, you kind of have to drop what you're doing and find someone who can address these issues. Whereas if you just have somebody like a trademark lawyer do it for you from the beginning, then you kind of don't have to worry until you actually have the registered trademark certificate in your hand.
Could someone potentially try put it in themselves, and then if they got the letter, then hire their lawyer? Could that
they can
work?
do that. Yeah, you can do that too. I've helped lots of people address like a lot of different types of issues. And just to give you an idea, I mean, there are very simple issues that can be corrected even by a DIY applicant. And then there are more complicated issues that a DIY applicant probably wouldn't want to address. And some of those more complicated issues could be like a likelihood of confusion. It could be a descriptive refusal. Sometimes an amendment from the principal register to the supplemental register, identification of goods and services, mark descriptions, entity. I mean, there's just a whole bunch of yeah, I mean, there's a whole, I mean, I want to say it's at least like under 15 issues total. And you could just be the lucky recipient of one issue, or you could be the unlucky recipient of 15 issues, of which the one issue, in my opinion, likelihood of confusion being the most difficult and complicated one to overcome. So it just depends, it just depends on how complicated your name is, how unique it is. Did you fill out the application properly? Like another issue that I see often, and it's a relatively simple issue that's not even grounded in trademark law, is entity issues. So sometimes people will say that they have like an LLC, for example, and they don't have an LLC. They just have, they're just sole proprietors. And so that's, you would think, okay, well, yeah, you can easily fix that. And yes, you can, but sometimes you're implicating transfer issues or assignment issues of a trademark when you don't fill out that entity portion properly. So then you have to make an extra expense to properly assign it if you haven't filled that part out right. So it's just, it's sometimes it can cost you more to do a DIY application if you do it wrong, as opposed to just paying someone in the beginning to do it right.
Yeah, that's a good point. And yeah, something I wouldn't consider. Although I'm in Australia, I'm familiar with that kind of setup as well, like sole trader or company and so forth. And I think that kind of draws me into the next question is, you're talking about the US here and trademark in the US. So if someone has a business somewhere else, they'll trademark it in their country. And is it true if you just trademark in the US, anyone else outside of the US can still use that name or mark? if it's not trademarked outside of the US?
Yeah, so trademark rights in the US extend to, I mean, yeah, US holders or US trademark users. So, like, we can't, US trademark laws, yeah, don't expand into other areas, except if you're talking about maybe common law trademark rights, which means that you haven't registered your mark, but you're claiming first use of your mark, somewhere here in the United States. So yeah, I mean, it eventually all goes back to the fact that you have to have some use in the United States in order to claim priority rights in that brand. Yes.
So, for example, if you were a global company, so I'm just saying Coca-Cola because it's the first one that comes to mind. That's in many, many places. How do they go about trademarking their brands collateral in all these other countries?
So they're going to have to, I mean, I'm sure if we looked it up, I mean, they've registered in a lot of different countries. And you can do that through one single application, like through the US based application. You can later on make designations for other countries. Yeah, and so there's added fees, of course. So, like, if you wanted to add 10 countries, it would get pretty expensive pretty quickly. Yeah. But a company like Coca-Cola, like, yeah, they should be doing that.
Yeah.
So yeah, but that streamlines it so that you don't actually have to file 10 different applications. It all is based in like one application.
Okay, that's good to know. Okay.
Mm-hmm.
And another thing that comes up is like there's a lot of different symbols. Like we've talked about the TM, but then there's the registered, the R1 in a circle and the C in a circle. I think there's a lot of confusion about what these all mean. There's also SM and so forth. Can you clarify what these all mean?
So a TM is just a placeholder. It's not a registered trademark. So somebody who, let's say I started a business tomorrow and I called it Exopi or something. Then I would put the TM next to Exopi if I wanted to test out my brand, make sure it's going to be viable. I'd put the TM on there. And let's say that a couple months from now, I decide to register the brand. It goes through the process. I wait 11 to 14 months. And it becomes registered, then I can go ahead and put the circle R on there. That means it's a registered trademark. And that means that I've actually received a trademark certificate from the USPTO. So if you haven't received it, then you shouldn't be using the circle R at all. You should be using the TM. And the circle C is actually for a copyright that has been registered through the Copyright Office. So that, copyrights are different than trademarks. You would seek to copyright something like, there are people that do copyright their logos, the design aspect. There are people that copyright, their poetry or their books or lyrics to songs, the sound recordings. So you wouldn't consider really trademarks with copyrights unless you're talking about something that's able to be copyrighted. And so just to be clear, if you're looking for a trademark, you can register a logo, a name, a tagline, a sound. But if you're looking to copyright something, then you're most likely talking about either a design or something in a written form of expression like lyrics or sound recording or, like I said, a book or something like that.
Okay, interesting. I was always under the impression that copywriting was as soon as you put pen to paper, that's your work and it's like copyrighted. Is that true? Or?
No, yeah, you're absolutely right. You do have a copyright in something the moment that it's, the pen to paper, as soon as you're done with it. But if you want to sue somebody for copyright infringement, you should have a registered copyright or a copyright registration, because you're going to be able to leverage damages. And also it is a requirement to sue in federal court. So it's just people who are really serious about the work that they're putting out and who make a career or a living off of it definitely need to consider registering it. Otherwise, it's otherwise your rights are limited, basically.
Yeah, it's interesting. And it comes a point of like where it does become crucial. At the beginning, you may not think so, but you need to find that balance somewhere. It's hard to find that. Would you have any advice for when someone should do that, or when they should start thinking about copyright or trademarking?
Yeah, like if there's somebody who's singing on YouTube to get discovered by either an agent or a publisher or somebody, then it's not very expensive. If you go to copyright.gov, it's like $35 to register a piece of work. So I mean, if you have $35 to spare and you're serious about your business, then go do it. I don't think that registering a copyright is as technical, and I don't think you need a lawyer for that as much as you would a trademark application. There are some people that still choose to have someone else do it, which is fine. But you can do it yourself.
Okay, that's interesting. I'd never really considered that, and that's just the US as well, right?
Mm-hmm. Yeah. Okay. Yeah, and copyright.gov. So the trademark office is actually USPTO.gov for United States Patent and Trademark Office. And then you have copyright.gov for registering copyright.
Okay. And what about for an international audience? Can you copyright somewhere else?
That's a good question. I actually don't do copyright registrations as often. I don't know if there's like an international. That's a good question. I'm gonna have to get back to you.
Yeah, no. At least you're honest. Didn't make something up.
Yeah, no.
That's super interesting. So we've talked about what trademarking is, like the purpose of it, and how you can do it, what the process is like, and what the differences between TM, C, and R are about. Is there any other advice you would give to people wanting to trademark their work, or just trademarking in general?
My biggest advice is that you need to be aware of what the heck trademarks are and what the heck trademark law is, because there are so many people that say, oh my gosh, I've been thinking about starting a clothing brand. Like that's the trend now, right? Everybody's starting a clothing brand or some kind of e-commerce store, and then they're like, okay, I already know my name, just go create a logo, let me put it on my e-commerce site. And then a couple months down the road, either they discover what registering a trademark means, or somebody has sent them a letter already or an email or has slid into their DMs and is like, hey, you're using a name similar to mine, you have to stop. And so my point is that you figure out later down the road that you've made a mistake. And so if there's power in knowledge, and knowledge in power in knowledge. And so you want to make sure, it's late here, I'm tired. But so you want to make sure that, that you have some kind of understanding of what this is all about and how it works. Even if you don't want to jump on submitting your application right away, that's fine. But at least understand the consequences. And the consequences are that if you haven't done at least a little bit of due diligence, that if you are aware that there's somebody out there who has a similar name to what you have chosen, that there is the potential for conflict down the road. So either you can choose to avoid that by choosing something completely unique and different from the get-go, or take the risk knowing that these might be the consequences.
Yeah, it's just, you're playing the risk game, right? And I think that's super important to keep in mind. So it's just a gamble.
Yeah, for sure.